not so simple pension fund dispute. It raises a constitutional issue of some substance and an issue of the greatest public importance.
Well, I think maybe you provide us with other than bioauthority, because my sister Leo pointed out to me, we'll have to see how we deal with that better.
Yes.
If you will.
Yes. Yes. Maybe put up a note on the question. I think it may be helpful because Leonard Friend has found a judgment which will be helpful to us. Well, it's the Viking pony case. Cost against whom? Cost against those respondents who initially opposed, which is the government. The government should pay for it. We're not suggesting that the commissioners personally should pay. So, because when you look at who are the respondents in the case, the respondents are the commissioners and the government.
I think the debate is not whether they should pay costs. I think that if you look at it, then manifestly their costs which are incurred, and to do with you, if you withdraw, I totally understand until that point. I think the debate is what happens once they decide to abide.
I appreciate that. Maybe put up sometime by the end of next week a short note dealing with that. Yes, it's the case. It's Viking Pony Africa. Viking Pony Africa Pumps, Pty Limited. Here's the passage. I don't think we need to put up a note. This is the passage we know. It's Viking Pony Africa Pumps Pty Limited versus Hydrotech Systems. It's 2011. 1 SA 327, Constitutional Court. And this is what paragraph 57 says, of the judgment says, of Justice Mkhweng. The city's dereliction of duty is largely responsible for this protracted and expensive litigation. The fact that the city quietly slid away into the remotest backroom of litigation ought not to be enough to exonerate it from the consequences of its failure to honour its constitutional and statutory obligations. It may not be an inappropriate response to its generally lackadaisical attitude to multiply the cost of this appeal. In the exercise of our discretion, we consider that it may be just and equitable that the city be ordered to pay the parties' costs. The difficulty is that the city chose to abide the decision of the Supreme Court of Appeal in this court. As a result, it made no appearance in this court, and the question of possible liability for costs was not debated with the parties and with the city itself. A provisional order that the city pay both Hydrotech and Viking's costs will be issued, and the parties, including the city, will be afforded the opportunity to make representations on whether the provisional costs order should be made final. That's how the court dealt with the matter. But perhaps if we can have a week, just in case we want to find something more that could be helpful to the court. We'll try to bring assistance. Those are submissions from those
Justices, this is in fact a difficult case to handle. I can give you some assurance that this is a similar case. If there was one, Mr. Pelser would have. So this is really a great submission. First of the submission I make on behalf of the President is it's a review to set aside findings of the Commission. The findings of the Commission itself has no practical effect. So if you go to the traditional approach, and it's perhaps best articulated in the well-known case of Giant Concerts, where it says that you have findings that has absolutely no practical effect, that should be the end of the matter. On a very basic level, the court is asked for an opinion, and the courts do not venture an opinion. So on that level, one would say the decision by the President to abide is commendable for at least three separate reasons. The one is that a commission of inquiry is established in a previous era. Prominent, respected judges are asked to head it. And the second reason will be that the foundational attack is an attack on the judges who presided in this commission of inquiry. And the third would be, we are here in terms of the judgment of Mabaso, which the court will find at footnote 10 or 11 of our heads, which says we must come here to assist the court on a constitutional level. But having said that seems to be, and the court grappled with that when the court asked my learned friend in a much more articulated manner, well, what is your course of action? Where do we get the power to set it aside? Because the Commission of Inquiry's primary function is normative, is adjunct, as the Safo case says, to executive, to the President's executive powers.
So, you starting from, I just want to get this right, because you opened up by saying there's no practical effect.
Yes. Well, let's take example.
No, I want to just test that.
Yes.
I want to debate that.
Yes.
You saying no practical effect,
Yes.
which would therefore mean what? On that line of argument, we can't give a remedy.
No. If you take, for example,
where this is leading.
yes, let me tell you exactly. If you take Power 1.6 of the terms of reference, which says that this commission will inquire into the validity of any contracts entered into pursuant to this particular program, whether there was fraud, whether you can cancel, and what its ramifications are. Now, if this commission actually pronounced upon that, it will not be binding. It wouldn't stop any other affected party to come to court to set aside that contract. It wouldn't even stop the government in whatever form, Treasury or the arms, the people in charge of the arms department in charge of arms, to come to court to set it aside. So on that level, the findings themselves don't impact. And as the President says, and perhaps just one paragraph I want to read from the exploratory affidavit, and that's paragraph 6, where it's explained. It says, the rationale for the application is that decisions as to what further actions, if any, should be taken should be made in reliance on the Commissioner's report. And that's paragraph 543 of the founding affidavit. The report does not recommend any further actions. In the 3 years since its release, no particular reliance has been placed on it insofar as I'm aware. Indeed, I'm not aware of any intended reliance to be placed on the report. So, assuming there's a finding that, and the President explains that there was no corruption, it wouldn't prevent the NDPP from pursuing corruption charges. He says that. He says an independent organization. So, the submission I make at the periphery level is that the findings are what they are, recommendations and no more. But of course, there's a different side to the coin. And that is not necessarily speaking for my client, but giving my strong views. And that would be, one will look at the purpose of the commission. And when one looks at the main purpose of the commission, and is curious that there isn't a word spoken about that, and that is the rationale for the program itself. That's prayer 1 of the terms of reference. And one would have thought that the commission would come out strongly on an aspect of that nature. Now I'm getting to the reason why I think, other reasons why you have the power and you may want to interfere. Now, if you take the situation is just after the birth of democracy, there's a commitment today, conservatively speaking, of 60 billion rand and rising, because we haven't paid the loans for the arms. Then the question is, whilst it fell purely within executive power, does a nation commit itself to that slice of its budget for the procurement of arms? Now that, on a more broad-based analysis, is not limited to an executive decision. More particularly, when one reads the extensive record, one sees that it's accepted, it would appear, throughout the world. It would appear, contrary to the sense of one's sense of what's right and wrong, that the entire transaction is clouded in secrecy, and it's, in a manner of speaking, and very loosely speaking, as Justice Davis mentioned, that to facilitate a meeting, people are paid. Now, in a matter of this magnitude, where a government takes a decision, a conscious decision that we're going to prefer an arms program against any other infrastructural program, one would have thought this commission would say, in future, let's learn from it. You don't do that unless perhaps you have a referendum.
What is the relevance of all of this?
Is the relevance of that's got to do this. If you're based on a value-based system as a court, then there's sufficient room for you to interfere. If you're simply going to take a very narrow view and say, but what is the practical effect of the findings? Nothing. Why should we venture an opinion? Well, that's the end of the matter.
But you're abiding by it.
I'm abiding. But I said to you, if you want to get
That's
more...
why I wanted to ask you, because if you say there's no practical effect on that sort of solution, it would then follow that you could then argue that therefore we should give no remedy at all.
Yes, that's the one part of the
And
coin.
that's why I want to ask you, is that your position or is it not your position?
No, I'm simply, my function here is to abide. So as counsel, I point out to you that particular
So
proposition.
this is of interest, but not necessarily...
Yeah, but if you're not interested in my own analysis of the matter, then yes.
But at the end of the day, we three have to write a judgment, and I need to know, speaking for myself, precisely what the President's attitude is.
Well, we abide. We abide. And I start off by saying you've got a very difficult case.
Which means, so
Yeah.
if I can push you on, which means abiding means you are not opposing the relief that Mr. Barnett seeks.
Yes, I mean, it's up to the court whether you want to intervene and interfere.
Yes.
But I must point out to you, what I've already pointed out to you, that the findings are what they are. Their findings is a recommendation, nothing more than that.
And therefore, are you suggesting to us that the difficulties we put to Mr. Barnett, right at the inception of his argument, namely, what is the cause of action, as I put it, that is something we want to tread very cautiously in order to actually come to a conclusion that there is a justifiable set of grounds for review?
Yes, we've dealt with that in our heads as judicial economy, which our courts have adopted, and we've given the citation of the Habitat judgment.
What do you say about judgments in other parts of the world, Canada and New Zealand in particular, which we actually engaged with this Barnett on, which essentially say that although a commission of inquiry is not binding, it is of enormous, it can be, and in this case, for the reasons you already articulated, of enormous political input, public interest, and that therefore it doesn't, they do have consequences. So that if, for example, the commission failed to perform in terms, like I put it in shorthand, of the principles of legality, that would be a justification for setting aside the funds.
Well, as counsel, we've gone with the latter view, and we've argued that on the basis of, if you read the report and you read the record, one gets the sense that unfairness permeates the entire proceedings, and unlike what was submitted to you, we would submit that where the unfairness impacts on the substantive findings in terms of the Albert decision, then the court has the power to interfere. But having said that, this is not administrative action. It may come...
I didn't
Yeah.
take them to say it was
No. But under the principle of rule of law or legality, there's sufficient scope for the court to come to that decision, yes. So we would say that on the objective factors, if the court, and I just want to make this point, if it's an interventionist court, and it's a strong theme that I personally take, then the court will say, well, if I read the record and I get a sense that, and to use a very loose term, that this was a commission that didn't apply its mind, then the court will say, well, we're going to intervene. It doesn't mean it will have any binding effect on any other commission, past, present, and future, because as you know, there are a number of commissions in place which serves the public good in that there's a ventilation of issues of national importance.
Yeah, you speak for myself. I'm trying to speak for my colleagues, but I'm going to speak for myself here. One is aware of it, that there are other commissions, and
Yeah.
that's why I think we all were probing what the basis would be of any judicial interference. Your commission, if I understand it, least implications. In a case such as this, where you say, and were your words, that the report is permeated, the proceedings were permeated with unfairness, this puts it into an extraordinary category.
Yes, it shouldn't have a binding effect on any other commission.
Well, it would only, because any review is fact sensitive.
Yes. And you recall that particular proposition was put up as a countervailing argument where the applicant wanted to impose the analogy with the powers of a public protector, which we found that would be a dangerous precedent. So we said that if you were minded to interfere, then you use fairness as a topic covering the entire spectrum of issues raised by the applicant in the uncontested founding affidavit and supplementary affidavit.
Just one final question for me on this particular point I might ask you. Don't want to put words into the President's mouth, nor yours, but do I take it from the basis of both your written submissions and what you're telling us now, that in effect what the President is effectively saying is, look, this may well be an exceptional case, and if you want to set it aside, that's your right to do. What I'm anxious about is that you craft a judgment that is going to make it exceedingly difficult for Commission of Inquiry not to land up in court in future on totally different bases, or where you actually overreach by extending the grounds of review.
Yes, I couldn't articulate it better. That's really the effect of what we're submitting. And that would be also the considered view of why the matter was not opposed.
Yes.
From the stage after when the record became manifest, because it's a new president, it's a new set of people who are looking at it, and that was a consideration. Yeah. The other thing that, and again, just that's disconcerting, because we have a situation where you take into account public interest, that is the enormous funds that are invested in conducting these commissions of inquiry.
137 million.
I'm sorry?
137 million.
Yes, and in context, we're a poor country, so one must look at the utility of what arises from these commissions. And if the ultimate gains arising from them are diminished by not giving practical effect, then one queries the purpose of the commission. So you've got to factor that into account. And there's another strong theme, if I may just mention, now that I'm on my feet. When you have an opportunity and you read the Sukla report of a founding affidavit, you recall that he comes in with his own application, which is then consolidated. And when you look at his notice of motion and his affidavit, which starts at page 695, I'll ask this court to please have regard to paragraphs 44 to 109 of his affidavit, because it's a consistent theme happening in our society, where an officer of the court, Mr. Sukla, unashamedly says on the affidavit, because he's got his own agenda, it's quite clear that he arbitrated, he wasn't happy with the amount of fees he was paid. He was paid, and I talk off the cuff, 7 million euros, but he wanted another 70 million euros or whatever, but don't hold me to the numbers, because this has been an exercise. When one reads this here, it's where we're going in terms of law and order as a legal structure. He unashamedly is in the center of corruption. He facilitates the corruption, and I would invite this court, and I use this term again loosely, to restore respect for law and order, to say something about his conduct. After all, he's taken the oath to uphold the constitutional values, not to break them. He's in the middle of everything, and I know Justice Davis says it might well be that the norm today is that you facilitate a meeting and you get paid, but you're facilitating a meeting to bring about a corrupt practice. It just can't be right. I mean, if Lord Scruton was shaken in his grave today and said, this has become the new legal order, he'll be screaming. So, and it's manifest, because when you look at the conduct of the Stella Segal case, at page 45 of our learned friend's heads, there's a repetition of the memorandum, which Mr. Justice Malabo said you've read. But you see in the last sentence, they say, we believe the investigator. But nothing is said about that, as if it's normal practice for people in influential positions to take advantage of those positions, to gain a little for themselves at the expense of a large sum of money which this poor nation struggling to provide clean water is now experiencing. So there's no proportionality in the personal benefits as against the great loss the company suffers. And what is worse, that none of these people are brought to task. They in fact appear in this commission to be the victims. And that is why, in terms of rationality, the unfairness permeates the ultimate result of the commission. Perhaps I've said too much. I must now talk about cost.
Mr. Kassim,
Yes.
before we go to cost, I think in that exchange with Justice Davis, you're trying to, well, you are sort of getting out of the firing line, so to speak, in terms of the difficulty. You say you're here to abide.
No, never frightened to face the challenge. Yes.
You're not of the court.
Yeah.
You said you want to come and make submissions.
Yes.
And that encourages us
Yes.
to pursue
Yes.
points with you.
Sure.
Isn't it?
Yes, of course.
Right. And starting from the Sutla situation that you just mentioned,
Yes.
your own way it deals with corruption.
Yes.
The gist of the applicant's case, or the fourth leg, or one of the four legs of the applicant's case, is that the commission failed to interrogate evidence to find the truth about what happened. You read the application?
Yes, yes,
Right.
yes, yes.
Now, I raise this in light of your allegation that Mr. Sutla talks about corruption. One of the terms of reference of this commission was to investigate whether corruption happened.
Yes.
Isn't it?
Yes.
So you can put the Sutla situation one side.
Yeah, he comes after, as you know. Yes.
Yeah, he comes after.
Sure.
But then let's look at the material that the commission had that mentioned Advocate Kawane,
Yes.
that mentioned Mr. Chipishe, that spoke about the extensive activities around the AP. In your own view, did the commission investigate the allegations regarding these people?
With great respect, and I say this to deference to the two very senior judges who presided, they did not. It actually cries out. There was prima facie case, and there were at least two levels of serious difficulties in the investigative progress. And the one was that if you take instances where there is a prima facie allegation of corrupt practices, for example, Mr. Sheikh saying you'll have to give to this other company, I forget the name, to get the contract. Yeah, it says to Bell, to get the contract, you'll have to enlist a middle company, is the company's name. But in that particular case, there was an ambassador who says, I had a discussion with the people before they said, we're not prepared to pay a bribe. Now, that to me, and here's an ambassador who makes it, there's no reason to suggest he's not available, and that is never pursued at any level. And secondly, there's no serious invitation to the evidence leaders that, look, you must test this evidence. Your job is not just simply to come and lead evidence. Your job is here to come and, in fact, help this commission unearth the issues which is burning out there in the public, and there one can have regard to what the press says and what authors have said, people intricately involved. So in each instance, I would with great respect submit that if this commission was serious about its functions, it would in fact have made strong findings insofar as corrupt practices is concerned. But more importantly, how do you then detect, how do you then avoid that in future? How do you pursue criminal charges? Or in the least, how do you pursue steps to recover ill-gotten gains? I mean, the disparity of the amount of monies, people that got money in these transactions, undead-headed money, there is actually no effective deterrent, save for one thing that I know, what's currently happening, and I think, Mr. Justice Malambo, you asked the question. You asked the question that what steps are currently being taken. I would with great respect submit to you that the only positive steps that one sees happening, and I had occasion to actually investigate this, arising from this 60 billion rand transaction, the only effective steps, and one knows very little about what actually happens, is from the point of view of the receiver of revenue, because they're not interested as to the causa for the income. They're interested, did the income come? And then, of course, there is a tax imposed and 150% penalty and interest. Save for that, it seems that when one reads these reports, to pertinently answer your question, crime does indeed pay.
Does indeed.
Yes, it's safe to say that. And
having said that,
yes. I must just make this point before, Judge. I'm not going to. The submissions I'm making now, it's pointed out to me in my own submissions, not that of my client.
I saw the note come.
Yes. If you said, Dave, it's the last case I have for the president, because on occasion I do give.
But you say you're representing the president.
No, but in all fairness, the president's position I abide. Questions are put to me as counsel, as an officer of the court, I owe my obligation to the court.
I want to come back to your argument about the practical effect of the findings.
Yes, yes.
Because you concede that on the three instances I put to you, the commission did not do what it was going to do.
Also, yes.
But the fact of the matter is we have a commission report that has findings that are there. Whether the president wants to act on them or not, but they are there. That's the last word spoken about a commission appointed by the president to check whether there was corruption or not in the arms. And that final word is there was no corruption. Am I correct?
That's the final word.
Of the commission.
Yeah.
Now, the applicant will come here and say, that final word can't be allowed to stand. Because that commission didn't do its duty, its job.
Yeah,
you say there's no practical effect.
No, there's no practical effect for three reasons. So I must make that very clear, Judge. Nothing stops the NPP from prosecuting people. That finding is not binding. It comes before a magistrate or a judge. He can't have regard to that finding to say, well, Mr. Shlongwana was exculpated, that's the end of the matter. So in that regard, it's not. It's not binding. The second, does it has persuasive value? I will argue that an astute presiding officer will say, before I give it any persuasive value, I must look at the content. When he looks at the content, he says, I completely disagree with the inferences. So again, it's not going to have persuasive value. Thirdly, it's there for public consumption. It reflects the values of our society. And on a personal level, I would submit on that issue, this court, if it wants to intervene, if it's an interventionist court, will say, well, we're no more in a rights-based society, we're in a value-based society. Of course I'm going to interfere. Those are my submissions.
I think you mentioned the public interest element yourself.
Yes.
Out there, the public tracked what the president did, and the commission appointed by the president came with findings that said there was no wrongdoing in the arms deal. And you saying anyone sticking to that finding, saying there was no wrongdoing, has no practical effect. That's what you say.
Well,
Even though you look at it from the public interest law perspective.
yeah, but from a cause of action point of view, if you go on the Giant Concerts case, from a cause of action point of view, and all the cases leading up to it, you say, look, am I expressing an opinion in the matter? And the moment you say, I'm expressing an opinion in the matter, then the natural reluctance is for the court not to interfere. That's the starting proposition which I put to you. That if you get a restrictive court, you get a court to say, I respect strictly my function as a judge, then you say, but look, I'm unhappy. When I read this, a judge can say, I think this is a whitewash, but does that mean I will interfere? Then you've got to ask yourself, what is the impact of the findings? That I started off. I then progressed to say, in the context of this case, it may be a narrow view because the terms of reference were extensive. The terms of reference was, what was the rationale for this particular transaction? And if the rationale for this particular transaction is, look, we want to educate South Africa, well, there's no issue. But the rationale for this transaction is, we're committing ourselves to billions of dollars, unknown at this stage what it will cost us, because the formulation is based on hedging funds and future interests, and there's a whole configuration that you never know what you're eventually going to pay. It's just one big hole, which if you're spending your own money, you'll never do, but you're spending public money, then you do it. And what are you achieving? And everything is cloaked in darkness. So I would have thought this commission would have said, in future, never do this unless it's in a transparent, open manner. Get the referendum, get your people to buy in. On that basis, this court will say, on the new value system enshrined in our constitution, of course we can interfere. Now, it's very difficult. It's a bit esoteric. It's a difficult issue, but that's why the court is the court.
I just want to pick up on what the President asked. You earlier said that you made a whole, a statement that if anybody would object, that it's important to reassert the rule of law, integrity, transparency, the values of the Constitution, which is what I think you were
Yes.
submitting.
Yes.
So that must then follow that if your analysis of this particular commission's procedures is correct, namely, that it was so fundamentally permeated by unfairness, then this court has an obligation to reassert the rule by actually saying, no, we have to have commissions that perform meticulously in terms of the principles of legality. That must follow from what you told us.
This is why we abide.
Okay. Now, let's not check that. Secondly, I just want to say, there are practical consequences here. You know, it's true, I think, Mr. Singh, that the Commission's inquiries are binding. But assume that the NPA does actually prosecute. Any defense counsel worth their salt will say, here is a Commission's inquiry which exonerated my client after spending 137 million rand of taxpayers' money on this lawsuit inquiry. It may not be binding, but frankly, it has some effect. Because, as you said, it was authored by two senior judges.
Well, I've debated that with Justice Monalvo.
Yes, I don't think it's quite as...
No.
I don't think one can be quite as cavalier about the consequences. I think it does have consequences.
No, it will be argued that it has persuasive effect, two very senior judges.
Because it's got persuasive
Yeah.
effect, both in terms of the public domain and in terms of potential possibilities. It's something that should stand if it is permeated with the level of unfairness. So that must be so.
Yeah, I cannot dispute that. Yes, but I did also make the caveat to say that if it's a judge or a magistrate of the caliber that we would like to do it, then they read this report and says it's not persuasive. The rule in Force versus Harbottle,
Yeah,
I forget the English judgment. It's not even admissible. Yeah. Yeah. Yes.
Can I just draw you to one other aspect? Since you're here, you may decide whether you answer it as counsel or in terms of instruction. We engaged in a debate with Mr. Budlander on the Commission's stance to the DP report, the Devil Voice and Printing.
Yes, yes.
What's your view about the correctness of the Commission's stance? That because this is confidential information that found its way to us as a Commission, privileged attaches to it, therefore, you can't take it down.
I think a strong view, once there's public interest component to it, it must be admissible, particularly in a commission. It's back to the Sage case where the court says you've got to investigate the intrusion and what is the object of the intrusion, and to what extent does it intrude in private matters as opposed to matters in the public interest. I think on the balance, the Commission should have had regard to it.
And I think not only on the basis that I can't have regard to it, but the information that's
Yeah,
there
sure.
that cries out for investigation.
Absolutely.
As well as the information the draft auditor general's report, right?
Also,
That
Mr.
sort of information to explore and check and inquire.
Also, I think in that regard that I was singularly impressed what was Mr. Murphy's affidavit, the man from the British Cedars Economic Office, and of course the German dossier, because those are thoroughly investigated matters. And they're there, and there's no reason why it can't be looked at. There was an argument put up that you should rather apply under the mutual legal assistance to bring the information here. I think that perhaps in a court of law, but not in a commission of inquiry. After all, the commission of inquiry's function is the pursuit of the true facts, which are determined once you've got all the evidence, and then you make reasonable inferences. It's not having a binding effect. It's there to bring a volume of facts on which meaningful decisions can be taken by the President.
You were going on to costs.
No, cost, there's no basis for cost in this matter. There's a substantial founding affidavit which is highly critical of reputable, high-standing judges in this country. We have an obligation as the President to say we will oppose until we understand the basis, which is only manifest when the record comes clear. When the record is made available, the President takes a very conscious and a very constructive decision that we're not opposing but we're abiding. Now that is commendable. You can't punish us for taking the right decision. Since that stage, we participate in a constructive manner, and we're here today to avert a wrong finding, to say the Commission's findings are equivalent to that of the public protector. I mean, we've got one legal system in this country, now we have another legal system parallel, challenging the courts, knowing the public protector. We don't want a third legal system.
Mr. Budden also said it was commendable that we were invited. The question is, for whatever reason, when you oppose to start with, it doesn't matter the ex post factor, you withdraw that. Surely up to a point, if you oppose.
Yeah, I don't want to take up too much time. If you want to find cost, it should be up to the point when I
That's
withdraw.
what I was going to
Yeah, I
ask.
mean that follows normal principles. I can't debate general
That's what I was
principles.
asking.
Yeah.
But beyond that,
No, beyond that, we can't.
Beyond that, we can't.
Yeah. Beyond that, it's those are our submissions. Thank you. Sorry, but I'm just inquiring. Thank you.
Mr. President, do you have anything to say?
No reply. Maybe make submissions by the end of next week on the question of costs.
Yes. Thank you very much. Thank you for your assistance in this matter. Thanks for the head of argument, especially President's argument about the public protection money. We appreciate all the assistance you gave.
We have handed up a list of cases.
Thank you very much for that consideration. So we're going to reserve our ruling, and then we will advise the parties when we are ready to present our judgment. Thank you.
Yeah. 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 Right.